Welcome to Wealthy Behavior, talking money and wealth with Heritage Financial, the podcast that digs into the topics, strategies, and behaviors that help busy and successful people build and protect their personal wealth. I'm your host, Sammy Azuz, the president and CEO of Heritage Financial, a Boston-based wealth management firm working with high net worth families across the country for longer than 25 years. Now let's talk about the wealthy behaviors that are key to a rich life. On this episode of the Wealthy Behavior Podcast, I'm joined by my colleague, Liz Meyer, an estate planning specialist here at Heritage Financial, to talk about estate planning and how it fits into the theme of wealthy behavior. Thanks for joining us, Liz.
Thanks for having me, Sammy. I'm excited.
Absolutely. Thank you. So you're a member of our financial planning team. And what does an estate planning specialist do generally?
So generally, an estate planning specialist is going to make sure that the client's estate plan that their estate planning attorney has put into place works with the financial plan that the financial team has put into place. So I often say in meetings that the best financial plan in the world you can have, and you can have the best estate plan in the world, but if they don't come together at the end of the day, neither one works. So it's my job to make sure that they come together at the end of the day.
And you've been practicing for a while, but also been in this estate planning specialist role for a while as well. So tell us a little bit about your background.
Correct. So I graduated law school and immediately from there started at a estate planning private practice and worked in that world for about 15 years. So directly with clients, one-on-one, making sure that, they had the correct estate plan in place from powers of attorney, healthcare proxies, wills, trusts, and then advanced planning techniques as well. And then in about 2021, I jumped over to a broker-dealer in Massachusetts to work in-house with their financial advisors. They have them all over the country and doing just what I talked about before as an estate planning specialist, making sure that their clients have the right plan in place to effectuate, what was best for them at the end of the day.
You've been a tremendous addition to the team. I've been excited to talk to you because I don't think we've really focused much on the podcast so far on estate planning. So maybe just taking it back to the basics, what does an estate plan accomplish for an individual or a family?
Sure. So I like to say that an estate plan really has two components to it. One, when the clients are alive, and then once when the clients have passed away. So in both, in my opinion, equally important. So estate plan when you're alive are what we consider living documents. So those are healthcare proxy and power of attorney. So if you become incapacitated and you can't make decisions on your own, whether that's, a healthcare decision or an important financial decision, you appoint people with these documents ahead of time to step into your shoes and make those decisions. If you don't have those documents in place, unfortunately, you're looking at a court getting involved with your family, knowing private information, and most people want to avoid that. So that's estate planning when you're alive. And then there's the more common, what people think about estate planning when you've passed away. So most people want to avoid probate court. Probate court is time consuming, public knowledge, and very expensive. So in Massachusetts, if you pass away with an asset in your name solely with no beneficiary designation, your family is going to be at probate court. So what we do is take a look at trust planning and does that make sense to have a trust as an owner or a beneficiary of your financial assets and real estate assets, both to avoid probate court and especially in Massachusetts for estate tax minimization planning.
So during life and at death, two important functions of an effective estate plan. Let's focus on them in order. During life, I think you mentioned healthcare decisions and financial decisions being
Correct.
made for you. And and in that instance, you are naming agents. What advice do you give to people just generally, if you can, in terms of who would be the best healthcare agent or power of attorney for them in their documents?
Yeah, sure. So we'll start with healthcare agent. Healthcare agent needs to be someone who isn't going to be too emotional at the end of the day. Because if you have a strict view on, I don't want my life prolonged, it needs to be someone who's going to make that decision because that's what you want, not what they want, right? So you need to take away that emotional aspect. So that's a big one on a healthcare proxy. Financial is, someone that you trust that can handles their own finances on a day-to-day basis and that has time, frankly, because it's a lot of work. In private practice, I had a lot of kids fighting that they weren't chosen as the power of attorney at the beginning. But then when they stepped in and realized how much work it takes when it's actually, time to do that, um, you need to have the time and the ability, really.
You mentioned in a healthcare proxy choosing someone who can make a difficult decision if that's what you want them to do. Are you putting those wishes into the document?
No, we do
Okay.
not.
Okay.
Because I don't know if you remember a while ago, there was a case in Florida where they had changed their mind and they had put it in the original document and then they changed their mind later. And there was a court decision on how do we do this? Which way do we go here? So we don't put it in the document and we tell our clients, make sure that you are consistently telling your agent, what you want at the end of the day.
What you want at the end of the day. And then you have successors in place, I would imagine, in both of those
Absolutely.
documents. Okay.
Absolutely. Yeah. Because a lot of times, you're going to have your spouse as the primary. And if there's a common accident, you want to have somebody named as a backup.
And in the planning for death situation, the key documents, then the healthcare proxy and the durable power of attorney, they're no longer in force
They
once you've
extinguish that
passed
debt.
away.
Yeah.
Yeah. So it's the
Correct.
will and trusts.
Will and trust. Yep. Everybody should have a will. A will is really an instruction to the probate court on how you want your assets distributed. So we want to, in a perfect world, not ever have to use a will, but unfortunately, things happen. So it's sort of, I call it a safety net in case there is something that needs to be probated. The big document, the important one, is going to be a trust. So I think most people should have a revocable trust at minimum, and then depending on their net worth in family dynamic situations, there may be times where more advanced trusts need to be in play as well.
So what does the revocable trust do?
So a revocable trust works like this. When you're alive, the grantor has full control over the trust assets. So it really works just like them. They can move money in and out of the trust, they can amend, they can revoke the trust. But when they pass away, their wishes are written in that trust, and the trustee steps up, the backup trustee that they've named, and is able to distribute their assets per their wishes in a private process without having to go to probate court.
Distribute their assets or hold them in trust for a
Yep,
time
depending
period,
on
right?
exactly. Yep, depending on how they decide they want those assets distributed. Some people will keep it in trust if they have minor children, or forever just because that's how they want it. They want their, someone else to control the assets for their children.
And so when you're looking at this, I would say that's the basic set of documents that you're looking at, right? The healthcare proxy, power of attorney, will, revocable trust,
Yep.
and there can be others in play. Maybe we'll get to that. But as you're reviewing those, are there things that you typically see or highlight that you feel people either need to pay more attention to after the passage of time, or things that you're finding yourself explaining to clients how they work that they may not be as familiar with when they initially put them together?
Yeah, I mean, I think the biggest one and probably the biggest part of my role here is understanding that having a trust is great, but if it's not funded, it means nothing. So there's this big misconception that, oh, I drafted and executed a trust with an attorney, I'm all set. But if that trust doesn't own an asset or is not a beneficiary of an asset, it's just a blank document. It doesn't do what it's supposed to do. So there's a lot of explaining to clients that this trust needs to be funded. So we will look through, their assets, what they own, and how it makes sense for that trust to work, whether it owns an asset or is a beneficiary of an asset. The other, big thing that I'll talk about with clients is at the end of the day, do they want their children to inherit the assets outright? Or are there some sort of creditor, divorce, spendthrift issues that they see with their children? And how does that work then? Should we keep it in trust? Who should be the trustee? So family dynamics come into play a lot as well.
Just in terms of when they get the distribution of
Yeah.
assets, or over how long a period of time. And that I would imagine is driven to a large extent by personal preference, but do you have any guidance as you're sitting across the table from people just to help them think through that topic?
Yeah, I mean, a lot of it, you're right, is personal preference. I would certainly say I think the greater net worth, the more I would lean towards leaving it in trust, especially if the kids themselves are well-to-do, because a lot of times those kids don't want more assets, within their own estate for tax purposes. So does it make sense to maybe look down a generation, or are there other children that maybe need it more, things like that. So that, and then obviously if there's any special needs or spendthrift, maybe there's a spouse that they really don't like, we'll talk through that.
So in that one, I think people generalize that if they leave it in trust for their kids, it will be protected, quote unquote,
Mm.
protected from divorce. But not to get too far into a specific area of the law, but it's not that black and white.
It's 100% not that black and white. Other than a prenup, there's no way to 100% protect this inheritance from a divorce. But the best way to do it is to leave it in trust with a third party independent trustee. It's not a guarantee, but if you want to be as safe as you can be, then that would be my recommendation.
So we talked about the types of people to choose in your power of attorney and healthcare proxy. In your will and your trust, you're choosing a personal representative and trustees. And
Correct.
okay, and any thoughts on who should or shouldn't be in those seats, and what do they do basically? How difficult is each role?
Yeah, so the roles are pretty similar. One's just within probate court and one's within, a private family transaction, if you will. So again, like the power of attorney, it's a lot of work. This is someone who you need to trust to be able to, be able to account for all the assets that are in the trust, be able to distribute them correctly, work with your financial advisor, work with your attorney to make sure that your wishes are fulfilled. As far as who you're going to appoint on this, for a typical situation, I think that a child can absolutely work, especially if it's everything's just going to go outright to the kids. It's not going to stay in trust. If there's an underlying circumstance where you want these assets to stay in trust, then usually I would recommend maybe having the child work along with a separate co-trustee. And that co-trustee doesn't have to be a professional trustee. It doesn't have to be a corporate trustee. It could be somebody else that you know, that you trust, a friend, a family member, just for checks and balance purposes.
So that they have to be good with finances, good with investing,
Good
or
with finances, good with invest. Well,
or
I
good
think
with
a lot of times they're
deciding
going to,
who should do that.
yeah, exactly.
Okay.
Good at deciding who should do that. And they have to have a good relationship with your family. A lot of times family dynamics come into play here, and this has to be somebody again who's not going to get emotional, isn't going to let the beneficiary, sort of overwhelm them with wants and needs. It's got to be someone who can take control.
So one thing I think we see together when we're in meetings is with the passage of time, clients have chosen or individuals have chosen their contemporaries. Maybe it's
Hmm.
their lawyer or friends and family as those personal representatives, trustees, and then ultimately they're faced with the reality, well, that this person is, my age or older and, is probably not going to be doing this forever. How hard is it for them to pivot and find somebody younger that they feel that their estate plan can age with?
It's hard. I'm not going
Yeah.
to lie. That's
Okay.
probably one of the toughest conversations I had with clients in private practice is who do you trust that can step in and do this? Because it's hard to look down a generation. They see their kids and their kids' friends as, not being on the same level. So, but a lot of times, if you have a good attorney or a good advisor, they can make recommendations as well. And they know somebody who, is that generation down. And you can meet and have a conversation with them. So that's usually the way I would go.
You touched on something earlier when you mentioned a benefit of leaving assets in trust can be if your kids are in a good financial situation as well,
Hmm.
which gets to something I don't see often enough, but I see it sometimes. I wanted your perspective on it. The idea of parents bringing their kids into an estate planning conversation where basically all cards are on the table, and a lot of times they don't want to do that, kind of share their finances and their details. But if your kids are very successful financially, it's probably beneficial to do kind of multi-generational planning together, or do you think it just opens a can of worms that, some of these things are better left undiscovered or unsaid?
No, I always believed when I was practicing to be as open as you can be. I think at the end of the day, that solves way more problems than it causes, believe it or not. So I think it's important for the parents to understand, exactly what their plan means for their children. And a lot of times that means the children need to have a say. I had meetings with clients just like you're talking about where the child said, I don't want it. I don't want the money. I don't even want it in trust. Um, in the parents had no idea they felt that way. So yeah, I think it's super important. I think it's important for the parents to know where the kids stand and vice versa.
So you talked about one of the, not necessarily a mistake, but one of the topics that you frequently converse with people about is making sure that their trusts are funded,
Hmm.
meaning, your assets are titled the way that you want them. Can you walk us through beneficiary designations and how they interact with an estate plan and things like a transfer on death or payable on death on financial accounts that traditionally haven't always had beneficiary designations attached to them?
Yeah, sure. So you'll see a lot of like brokerage accounts or retirement accounts that will have a transfer of death or payroll on death. So those are fine. You can name an individual, but you can also name a trust. And the benefit of naming the trust there is sort of twofold. One is, well, we'll talk about non-qualified accounts on this one, is twofold. So one, if you just name an individual and that individual passes away before you do, you're back in probate court on that account, right? So the trust sort of builds in the contingencies there. So you're not going to have that issue. And the second point, which we haven't really gotten into, is trust planning for estate tax minimization. And that's where titling the trusts on those accounts becomes even more important, in my opinion, than just simply avoiding probate.
So, and by non-qualified, you meant non-retirement accounts?
Non-retirement, yeah.
Yeah. So then on the retirement account side and on life insurance, whatever you designate as the beneficiary is going to dictate, even if your intent was different
Yep.
when you crafted your estate planning documents.
Absolutely. So, you'll see cases, or I've seen cases when I was practicing, where a client had a trust done, it had all their beneficiaries, their wishes laid out in this trust. They passed away. The kids came to see us and they said, well, here's the trust and here's the life insurance policy, but only my sister Sue is the beneficiary on the life insurance policy. But this is what a trust says. So the trust goes equal. So we're going to get it, right? Well, no, you're not, because the beneficiary designation rules. So that's again an important part of our role, is to make sure that those financial accounts are titled correctly. So what the client wants at the end of the day is actually going to happen.
Are there any other mistakes that people make with beneficiary designations? A lot of times I see the estate as the primary
Yeah.
beneficiary. Okay, you're already shaking your head.
Yeah. So, I mean, there are times very specific. I won't even get into it because we'll be going down a rabbit hole, where having an estate named does make sense, but it's few and far between. And again, most people don't understand an estate means that's probate. That means somebody's going to court and probating your will, and the will determine how those are distributed, which is okay. But again, your beneficiaries it's time consuming, expensive, and again, public knowledge. And 9 times out of 10, you want to stay away from that.
What about when the contingent beneficiary is blank?
That's an estate problem as well. If the primary beneficiary passes away and there is no contingent, then it's probate again. That's why naming a trust, it checks all the boxes, right? So that's not going to happen. It has all the contingency language built in.
Not to get too technical, but not every trust is ideal as a beneficiary, right? There has to be certain language in the trust. I guess I'm asking you, should you ask your attorney before you make
Yeah,
that change?
you should, and it's more, not every account is right for a trust, right?
Okay.
So you'll hear a lot that retirement accounts, trust shouldn't be beneficiaries of that. And for the most part, that is true. For the most part, because of the rules, the tax consequences, most times an attorney is going to recommend that you have an individual named as your beneficiary on a retirement account. So trusts aren't perfect for every account, but the majority of them they are. And that's where the attorney and the financial advisor really need to work together to make sure that the plan, like we talked about at the beginning, comes together.
But if the retirement accounts are substantial and your plan would benefit from trust being the beneficiary, there are workarounds, but it just may not be as ideal as leaving it to people outright, right?
There are definitely workarounds, and there are marital trusts that can make sure that the spouse continues to get the stretch. There are downsides to that as well, but in some circumstances, specifically maybe federal estate tax issues, it makes sense.
So we haven't talked yet about that. You did a great job outlining the estate planning documents and how they're helpful in disability and death situations, but we haven't touched on the estate tax
Mhm.
benefits of an estate plan. So maybe at a high level, walk people through the estate tax and what is part of your taxable estate.
Sure. So we'll talk first federal and then talk mass, because I think federal isn't going to apply to most of us, right? So currently, if a person was to pass away with more than approximately $14 million in their name, then their estate could be subject to a federal estate tax. For the federal tax, there's a spousal exemption as well. So really it doubles to almost $30 million per couple. The federal tax has this wonderful thing called portability as well, which means you don't have to do as much planning in a spousal situation for the federal estate tax for the first person to die. So for example, say my husband and I had $40 million and I didn't do any sort of estate tax minimization trust planning. I pass away. My husband wants to make sure that my 14 or $15 million exemption is used. He can file what's called a portability election with the IRS and say, please make sure that my wife's 14 or $15 million estate tax exemption was used. And that's fine. It's allowed. Massachusetts, on the other hand, does not have that. So currently, the Massachusetts exemption is $2 million per person, so $4 million for a married couple. But unlike the federal tax where we have that portability, we don't have that in Massachusetts. So that's why it's so important in Massachusetts for couples to have estate tax minimization planning built into their revocable trusts. So that is what I will look at every review I do here to make sure that, not only is the correct language in there, but we also want to make sure that each spouse has that trust funded with typically a minimum of $2 million to make sure that when they pass away, that $2 million is being used and they're not passing it on to the spouse and basically doubling what their tax could be.
And the mass tax, it doesn't have a fixed rate, right?
No, so that's the other. So the mass tax is gradual and the max is about 16 or 17%, where the federal's 40%. So big difference there. But again, most people aren't going to see that federal state tax, but most people in Massachusetts will see a mass state tax.
Most of the people that are working with an advisor that would be interested in this topic. Yeah.
Yeah. I
And
mean,
so,
if you just look at the real estate values in Massachusetts, right, alone, so.
and that's why I would imagine part of why they recently increased the exemption from 1 million to 2 million.
Exactly.
One thing I think people get confused about is gift tax and the annual gift exclusion.
Yep.
And can I gift more? And if I gift this to my kid, does he have to pay tax on
Yeah.
it or she have to pay tax on it? Can you just walk people through the primer of
Yeah.
gifting, just gifting in general, and then
Yeah.
where, if anywhere, a gift tax comes into play?
Yeah, sure. So gifting is a common planning technique people use to reduce their estate tax, right? So like we talked about, the federal estate tax is about 14 million. If you're over that, you'll hear people say, let's gift to get assets out of our estate. Well, why do we want to do that? We want to do that because not only are you getting that asset out of your estate, but you're getting the growth on that asset out of your estate. So that's why gifting becomes important. Now, the federal estate tax that we talked about, that's about 14 million, and the gift tax work hand in hand. So I think the easiest way to explain it is an example. So say I gift $2 million during my lifetime. That means that when I pass away, my exemption is going to be 12 million. So whatever you gift during your lifetime, that's going to eat away at that federal estate tax exemption. So if I gift 5 million, I'm only going to have 9 million left. So they work hand in hand and they're not separate taxes, if that makes sense.
Yep.
For Massachusetts, there is no gift tax, so you don't have to worry about it as much. Although you have to file a gift tax return for anything that you gift over the annual exclusion, which right now is $19,000 per person, you're just gifting that to let the IRS, you're just filing that for the IRS to tally how much you've gifted, and you don't actually nobody owes a tax until you've hit that threshold, the 14 or $15 million threshold, whatever it ends up being at the end of this year.
So a lot of times people shouldn't feel bound by that annual limitation.
Absolutely not.
And there
No.
are some freebies, right? You can, I
Yep.
think, pay medical expenses directly to an institution
Yep.
on someone's
Yep.
behalf. Education. Are there any else?
Those are the two big ones.
So anything else that you feel is helpful for people as they're starting to wrap their heads around estate planning as a concept and why it's important, and mistakes that you see, anything that you feel could be helpful to our listeners that I didn't touch on during this overview with you so far?
I just think it's really important for people to keep their estate plan up to date. I think that's, I say every 5 years, you should at a minimum review your estate plan. And that means not just going over the documents, but having a family discussion of, have things changed? What's changed in our world? What's changed in, the tax world as far as rules and regulations? And from there, do I need to update it because of changes that have happened? So I think that gets overlooked a lot, that when families dynamic changes, or, I retired, or we bought a second house, we have a kid who just graduated from college, or things along those lines, that a lot of times that means your estate planning is going to change. And so you need to take a look at that and maybe have a conversation with your attorney.
That touches on one thing that we hadn't brought up, which is owning real estate in another state.
Mm-hmm.
And just ancillary probate, what that means and how you can avoid it.
Yeah. So if you own assets, real estate in another state, then if you passed away with that in your name solely, not only are you having a probate in Mass, you're having a probate in whatever state it is that you own it in. So
Avoiding it by having it owned by a trust, or
trust, maybe an LLC. It depends. It's going to depend on what it's used for. It's going to depend on those states' rules and regulations as well. So it's also very important to meet with an attorney who's licensed in the state that you own that property in.
Great. And then we touched on, I think, the most common estate planning documents, but are there any other techniques that you see utilized fairly regularly that we should just elaborate on?
Yeah, so I think probably the most common one is going to be an irrevocable life insurance trust.
Okay.
And that comes into play for a lot of individuals where, life insurance is something that most everybody has. And then you take it to the next level of, does it make sense to remove these assets from my taxable estate? So in case there is an estate tax due, my family has liquidity to pay for whatever that estate tax may be. So the way an irrevocable life insurance trust works is it becomes the owner and the beneficiary of a life insurance policy. And there's an individual, obviously, who's the insured. When that person passes away and the policy gets paid out, that policy is outside of the insured's taxable estate. And the trust can read whether it goes to the kids or stays in trust for the kids. Again, you can make whatever language you want in that trust. But the benefit is, although the trust can't say it's to be used to pay for your taxes, because otherwise that sort of defeats the whole purpose, it gives the family liquidity to make that payment if need be.
Great. Well, Liz, I really appreciate this overview, and I'm sure our listeners will as well. It's a great primer on estate planning and opens the door for us to have maybe more detailed conversations if the estate tax laws ever change, or there are things that we feel like we need to cover more in depth. So thank you for your time today.
Thanks, Sammy.
Thank you for listening to Wealthy Behavior. If you found the conversation useful, please leave a review wherever you listen to your podcasts and share this episode so those around you can live a rich life too. We appreciate your feedback and questions. Please email us at wealthybehavior@heritagefinancial.net. For more insights, subscribe to our weekly blog at heritagefinancial.net and follow us on Facebook, Twitter, and LinkedIn. Check out my personal finance blog at thebostonadvisor.com. Wealthy Behavior is produced by Michelle Kakamis.
This educational podcast is brought to you by Heritage Financial Services, LLC, located in the greater Boston area. The views and opinions expressed in this podcast are that of the speaker, are subject to change, and do not constitute investment advice or a recommendation regarding any specific product or security. There is no guarantee that any investment or strategy discussed will be successful or will achieve any particular level of results. Investing involves risks, including the potential loss of principal. There has not been and will not be any compensation exchanged between Heritage Financial Services and podcast guests or recommended resources.